right, it's August the 16th, and August is what they're calling out there Make a Will Month. And we are today in the offices of Doug Price in Tempe, Arizona. And we're going to be talking with him today about this whole idea of estate planning, making a will, putting a trust together. And so, Doug, it's a great pleasure to be here with you today. My name is Rick Allen. I'm with 30-Fold Media. And so we will be talking about this whole process. But let's just start with an opening statement if we can, Doug. Just go ahead and introduce yourself to the folks, and we'll get into some questions then about this whole idea of estate planning. Is that okay?
Thank you, Rick. I appreciate that. I'm an attorney licensed by the State Bar of Arizona. I got my license first in 1983. I worked for a firm for a couple of years and started my own practice in 1985. And I've been a sole practitioner basically ever since. My clients are individuals, families, some small businesses. That's my focus.
Okay, fantastic. And you're here in Mesa.
See me. That's
Okay.
Mesa, Tempe, Chandler, and really throughout the state.
Sure.
Just did something over in La Paz County for somebody.
Oh, wow. Okay. Yeah, that's a little ways away. Right. Very good. And so can folks find you online as well?
Yes. Our website is azlegal, azlegal.net.
Okay, azlegal.net. Very good. And I suppose you got one of those newfangled devices called a telephone as well. How can they reach you there?
And with our office phone number, that is 480-345-8100. And most of those calls go directly to me, to my cell phone.
Okay, very good.
7 days a week.
All right, 7 days a week. Wow, you're on call then.
I'm on call.
All right. Well, Doug, thanks for spending some time with us today and spending some time with the audience of this video. So let's just get into this whole idea of estate planning, because I know we make plans for vacations. We're going to go on vacation. We're going to be there a week. And the thing that kind of hits me as an individual is the fact that we've got not the rest of our life at the point we're going to use this estate plan, but the people that we leave behind have the rest of their lives. And it just makes sense as a consumer that people would prepare for that. And we do prepare for it somewhat. People get life insurance to prepare for that time. But estate planning, tell me a little bit about that, and what is an estate plan, and why would I get one?
The estate plan is for the living. And we do what's called a living trust, and that's for you while you're living. Unfortunately, the chances of you becoming incapacitated or disabled are far greater than of your dying. So we do have documents that will come into effect upon your death. But most of our documents are powers of attorney, financial and medical, and other things that are in effect while you are alive. And to make sure that we know who's going to make the decisions, financial and medical, and to make sure if there's any gifts to be given, what's going to happen with that, tax preparation, what's going to happen with that. All those things are covered. Mm-hmm. And yes, we do cover the events at your death, but that's only a small part of what we cover.
Okay. All right. So it's planning that's about more than just the fact that, oh, now I'm gone. What happens to my stuff?
Much more.
Okay.
And let me just show you something here.
Certainly.
This is our typical estate planning portfolio that we might prepare for people.
Mm-hmm.
This doesn't have any papers in it, but it does have the tabs. You can see there are many different items here that are prepared, most of which relate to your life as it is right now,
okay,
while you're alive.
All right, great.
It also, of course, makes things a lot easier upon your passing, because we know who's going to be in charge of the estate. We know who's going to get your stuff.
Mm-hmm.
Those are two things that need to be spelled out. If they're not spelled out very clearly, you're going to have problems. because the families are going to fight over those things.
Yeah, inevitably.
Very inevitably,
Yes.
unfortunately.
Yeah, unfortunately, yeah, we're all people, and money and death change people and change attitudes, doesn't it?
You don't know your family until you've shared inheritance with them.
Absolutely. Okay. All righty. And so powers of attorney, medical documents, that what happens with those? What do those do for us?
Well, for example, with the financial power of attorney, if you become incapacitated, you might have trouble paying your bills. You won't be able to go online or to write a check or do anything.
Mm-hmm.
And so you're going to name somebody that you trust to say, if I'm incapacitated, I want you to pay my bills and have access to my accounts.
Mm-hmm.
And they will have access because they need to show the power of attorney to the bank, and then the bank grants them access. And they have to use it for your benefit. And they're held to what's called a fiduciary standard, which means that they must take care to make sure that this is for your benefit and not for their own personal benefit.
Okay. Okay. So it's not their personal Visa card to go on a little shopping spree.
They don't get a free vacation out
Yeah.
of it.
Okay.
Not unless you want to give it to them.
Right. Right.
That's your decision.
Which you could designate in the trust.
You could designate whatever you want.
Yep. Okay. Very good. All right. So that's the financial document. The medical documents. What do you put together
There
there?
are multiple medical documents,
Mhm.
including the medical power of attorney, something called a living will, which is not a will, it's a living will, it's a medical document.
Mm-hmm.
And that's to basically direct people if I am in a terminal condition. I do or do not want certain things done, such as artificial respiration, artificial feeding. Do I want comfort care? Do I want to be made comfortable?
Mm-hmm.
Most people would say yes. But that puts it in writing, because there have been some years ago a Supreme Court case for the United States Supreme Court about this, and they did not have anything in writing. And the Supreme Court said, well, you are welcome to give directions to people about your medical care, but it has to be in writing.
Mm-hmm.
You can't just tell people and say that's going to be enforceable. So these are in writing, they're signed, they're witnessed, they're notarized. They're going to hold up in court, they're going to hold up with the doctors and the hospitals, and that way you know you're going to get the care that you have directed. There's actually a new form that we're doing now for in the event of dementia, do you want to be force fed or do you not want to be force fed? Most people would say, no, don't force feed me. We have a form that says that. Don't give me food unless I'm taking it willingly, unless I appear to be enjoying it. Don't just force it on me.
Okay.
And that's in writing, so that can be put with a nursing home or a care center, and they will know that you do not want to be force fed.
Okay. All right. Very good. And that would be important to an individual, because I know some people, when they come to, I guess, end of life situations, it's like an attitude of, no, keep me going or let me go.
Right.
All right. Okay.
So
that's the way we can make that decision for ourselves.
This is making your wishes known in advance. We also have what we call final disposition instructions. That is having to do with, do you want a burial? Do you want cremation? And how detailed you want to be. We recently had a client who gave me probably some of the most detailed instructions I've ever heard. He's going to be cremated. He was from Hawaii originally. He's going to be buried in the ocean in Hawaii with his cremains. He's going to have some of his cremains attached to a fireworks show. And he's going to go out with a bang, and he's going to have his sister use his phone to text people saying, we hope you enjoyed the show. This is our final gift to you. And he's very specific about what's to be said, when it's to be done. It's going to be on a Friday night.
Okay.
And you can be as specific as you want with these things.
Okay. All right. Fascinating. Fascinating. Sounds almost like a plot to a movie. Wasn't there a movie not long ago with, let's see, what was it? Robert, oh, come on, I can't remember his last name now. Robert Duvall, about planning his own wake. and he wanted to have it before he went, so he'd be able to go.
That's a good idea.
Interesting. Okay. All right. So now that new document, is that an Arizona only thing, or is it
Yes.
okay? All right.
Everything I do are Arizona documents.
Arizona specific. Okay. All right.
I'm not licensed in any other state.
All right.
We have clients in other states
Mhm.
because many of them have relatives that live here or pass away here.
Mhm.
And so they may contact us regarding their grandfather or their uncle or their friend that lives here.
Gotcha. Okay. All right. But the person who is subject of the specific will trust needs to be an Arizona
Everything we do
resident.
is under Arizona law.
Arizona law. Okay. All right. Very good.
And if we do a probate, it's going to be in an Arizona court. We don't go to other courts in other states.
Okay.
And the laws are very different between states.
All right. Yes. Yeah.
So I've worked with lawyers in other states who we contacted to help us in a case that might have property in the other state, or might have a person that needs to be dealt with in the other state, and then we'll ask for help.
Okay.
Because I'm not licensed in those other states.
All right. What if a person gets their estate planned by you while they're here in Arizona, and then I've seen cases where they decide, well, I'm moving back to Minnesota now. I'm going to live with my kids, or cases where, for whatever reason, at the time of their demise, they're no longer in Arizona. What happens then? Is their trust still valid?
It most likely is, particularly with a trust. And a trust can have property from other states as well, which is one of the advantages of a trust.
Okay.
However, it's always good to have a local attorney where you live and have them review your documents, make sure they're in keeping with the local practice. That's a very good idea.
Okay.
I can tell you that I probated wills from other states, from New York, among other places, where the people moved to Arizona. They never revised their will in Arizona. But if it was a valid will in that other state, we will recognize it here, and we can probate it here.
Okay. All right. That's a word that scares people a lot, probate. It strikes fear in the hearts of men and angels. What does that mean?
Well, it is a process for going to court and either presenting a will, if there is a will, or if there is no will, there's a way to do that as well. But the court is definitely involved from the beginning to the end of that process. Often they're informal, and you don't have a lot of hearings, which is wonderful because it keeps the cost down. Still, there is a cost. And that's another reason to do a trust, because if you do a trust properly and you put your property into the trust, and that's where a lot of people miss the boat. They do a trust and don't put anything into it. But for example, you need to put your house into the trust. You need to put large bank accounts. And by large, I'd say $75,000 or more. They need to be in the trust. And if you do that, you will not have to do a probate, because it's going to be done by trust administration, informally, without court involvement. And it's going to be much cheaper, much simpler, and much quicker.
Okay.
In addition, when you do a trust, you get some tax benefits.
Okay.
And the tax benefits are that you get what's called a stepped up basis. And the basis is the cost of an item. So just for example, let's say you buy a house, and you bought it a few years ago when the market was a lot slower, and you bought a house for $200,000 in Arizona. That same house is now worth $500,000. So if you use the original basis of $200,000, subtract that from $500,000, you get a $300,000 gain. That's a taxable gain of $300,000 that you'll pay income tax on. If you use a stepped up basis, which is the basis at the time of your passing, that's going to be $500,000. So now you have a house that's worth $500,000. The basis is $500,000. You subtract that, you get zero. The gain is zero. The tax is zero. Incredible tax savings. That also works with stocks and bonds and other things. So another good reason to have a trust.
Okay. Zero is a nice round number.
Particularly when you're dealing with the taxing authorities.
Yes. All right. Very good. So that's tax uh, indications, and you mentioned some things there. And one of the questions that I see is, how do I fund a trust? What you just mentioned about putting things into the trust, is that what is meant by that question?
Absolutely. And
Okay.
what we do in our practice is we always make sure that your house and your real property is put into the trust, and we will do deeds from you as the owner to your trust as the new owner. And that way the property is clearly in the trust, it's recorded. In fact, I just was doing one earlier today. We saw somebody in the hospital yesterday. He had a will. He decided they want to avoid probate.
Mm-hmm.
So we did a trust. Unfortunately, he's still mentally capable of doing that. So we met with him, we did the trust, we had him sign a deed. I just recorded that deed today, and it's in the process now of being uh, taken by the county recorder's office and given an official number. And that house is now in his trust, and there will
Okay.
not be any probate.
Okay. Fantastic. Fantastic. And that brings up a good issue that people, I think, may miss in the idea of estate planning, is that when you do these things, we've all heard that statement in a million movies: being of sound mind and body, I, so and so, bequeath this to this person. Um, but that's important, isn't it? That the person be mentally cognitive and capable of making those decisions, so you don't want to wait until they pass that point. Isn't
Right.
that pretty important?
And you sometimes, if there's a question, I have a little test I give people about their mental acuity. And do you know who the president is? Do you know where you are? Do you know who your family members are? Do you know what day it is? And if they can't answer those questions, I may not be able to help them
Mm-hmm.
because it's too late.
Yes. Yeah.
Uh, there is a strong presumption that somebody who's signed a will is mentally able to do that, and the person who's attacking the will, probably because they're not included in the will, they're attacking it, and so they're going to say, well, this person was incompetent. But they have to prove that by clear and convincing evidence. And they have to prove that the will was the product of some kind of delusion or incompetence by clear and convincing evidence.
Mm.
That's a high evidentiary standard.
Yes.
So the presumption is that you are competent. But again, nobody wants to borrow trouble or get into litigation.
Mm-hmm.
And I'm cautious about that. If somebody seems like they're not really understanding what's going on,
Mm-hmm.
I'm not going to do an estate plan for them.
Right. Right. So you want to do everything you can to erase all doubt.
Right. You want to make sure that everything's clean, that it's going to hold up, and that there's not going to be problems in the future.
Okay. All right. And you explained earlier about fiduciaries and what that is, but let's just reiterate that, because that's a term that gets thrown around a lot. And I guess there are a lot of times in life where people might say we have a fiduciary responsibility. So just in general, what does the term mean, so we are all clear?
That means that if you have something that's entrusted to you, that you're in charge of, that you're going to take care, it's going to be the reasonable person care, that you're not going to mismanage it or throw it away or take it for yourself when you shouldn't.
Mm-hmm.
For example, if you have a bank account that you're keeping for somebody, that money needs to be used for that person, generally for their health, education, and welfare, and not for your own personal benefit. And if you try to take it for your own personal benefit, you may not only have a civil problem, you may have a criminal problem. So you are given a great amount of responsibility, and you need to use it wisely.
Okay. Yeah, very, very much so. And I hear sometimes people refer to themselves as I am a fiduciary. What what does that mean different than if someone were to entrust me with such a responsibility? What does it mean to be a fiduciary?
Well, there are two kinds of fiduciaries. There are unlicensed fiduciaries, and that would be you or any other ordinary person. And there are licensed fiduciaries. They actually have a license given to them by the state to be a fiduciary. And one that I work with frequently is East Valley Fiduciary Services. They're licensed. And that's a wonderful thing, because if there's a problem within a state and the family can't decide what to do, we can get East Valley Fiduciary to take over the administration of the estate. They're going to be impartial, they're going to be fair, they are licensed, and among other things, because they are licensed and responsible, they will not have to post a bond, which the unlicensed fiduciary may be required to post a bond because they're not licensed. We want to make sure that they don't take off with that money and go to Tahiti. That's why the bonding company is in there, and if they do go to Tahiti, the bonding company is going to chase them down. You're going to find them. You're going to bring them back and get the money back too.
Doug the bounty hunter be after you.
Right.
All right.
It won't be me, but it'll be somebody.
Sure. Yeah, absolutely. Absolutely. Be after them. Okay. So those are important things to know then. So when you become a fiduciary, you're taking some big responsibility on, and I guess it would be important to communicate with that person that maybe you're assigning within your estate that they are capable and they are likely to be around. So you wouldn't want let's say necessarily your 101-year-old grandfather to be, because they might go before you. So how does one choose? What are the criteria that I would use for choosing somebody if I was choosing somebody that's not a licensed fiduciary?
If you're going to choose a family member, and people often do, they usually choose somebody from the next generation.
Mm-hmm.
And they can be called the substitute trustee in a trust, or in a will, the personal representative. And both of those are fiduciary positions. So you want to get somebody that's younger, generally. Somebody of the same generation, the problem is they may pass away before you do.
Mm-hmm.
Somebody of an older generation, really not recommended.
Yeah, okay. That
And-
makes sense.
And we usually have a series of people. So, I'd like my son to do it.
Mm-hmm.
If he's not able, my daughter. Or maybe I'd like to make my son and my daughter as co-trustees, so they're both in it together.
Mm-hmm.
And then, if neither of them can do it, then maybe we'll appoint a licensed fiduciary.
Okay.
So we have plans, alternative plans, for whatever might come in the unknown future.
Okay. Is that fiduciary the same as being the executor of the estate, or is that something different?
That's an old-fashioned term.
Okay.
We haven't used since 1974.
1974. Oh my goodness.
The executor, or if it was a female, executrix. But those terms are no longer used. It's now the personal representative in a will situation. As I say, in a trust, it's the substitute trustee.
Sounds like I need to go back to law school. Wait, I've never been. Can't go back to someplace you've
Well,
never
there are
been.
other states that might still use those terms.
Okay.
Not in Arizona.
Not in Arizona. So 1974. Wow. Okay. Things do change, even in the law.
All the time.
Yes. Yes. Constantly. Okay. Another question that comes up, because I'm sure that you probably do estates for people who are single, and sometimes for people who are married, or to people who are together. And so sometimes people own property together. It might be two spouses or non-spousal relationship. How does that work out within the context of an
That's a
estate?
great question. There are many ways of joint property ownership. And the sort of standard way that's traditional is called tenancy in common. And if you own property in tenancy in common, that's two or more people. If one person dies, the property does not go to the survivor. It goes to the heirs and the beneficiaries of the person who died. So that might be a dangerous way to own property if you think you're going to get it inherited from them.
Mm-hmm.
But that's kind of the standard traditional way of doing it. The other ways are joint tenancy with right of survivorship. In that situation, and this could be a house, a car, a bank account, any kind of property, joint tenancy with right of survivorship will go to the surviving joint tenant or joint tenants. It does not go to the heirs of the person that died. So that's how you are sure that you're going to get that property upon their passing. The other thing is with the husband and wife, we have community property in this state. And community property also has a right of survivorship. Community property with the right of survivorship. That means it's going to go to the surviving spouse. And even if it's not in a trust, with that you get a stepped up basis. So there's a tax saving on that.
Okay.
So there are many ways of doing it. Joint tenancy is a way to avoid probate. If you have everything in joint tenancy, you'll never have to do a probate. Here's the problem. The problem is that joint tenant is already an owner of your property. There's nothing to stop them from selling the property right now, or if they get into legal problems and have creditors, having their creditors attach liens to the property, which you thought was yours, but it turns out now you've got a joint owner, it's also theirs. So there's some real risks with that. One way around that, again, trying to maybe there's a small estate, you don't want to do a trust, you don't want to do probate either. You can do something called payable on death. So if I have a bank account, I can have $100,000 in the bank account. It's all mine. It's not joint tenancy. I'm going to say payable on death to Rick.
Well, thank you.
And that means on my passing, you get the bank account. All you
Okay.
need to do is show the bank death certificate,
Mm-hmm.
and it's yours. But it's not yours until I pass.
Okay.
So you can't take the money right now when I'm not looking, or close the account when I'm not looking.
Okay. And it's fair to say I should not augment your demise.
That would be very poor. There is a statute on that. I actually had a situation some years ago where my clients were murdered by their daughter.
Mm.
She was not eligible to receive any property under that estate, under Arizona law, because when you are the person that has harmed the deceased, you're not going to benefit from that.
Okay.
And there's a statute right on point.
All right. Good. Well, that's good to have that there then.
Yeah.
Gives you a little bit of insurance.
She had problems before the murder, but they were trying to take care of her, but she ended up being more trouble than they expected.
Okay. Sounds like a Lizzie Borden situation.
It was not good.
Yeah. Okay. All right. So if you have plans to that effect, you probably should alter those plans. All right. A life estate, is that something different than we've been talking about for the last few minutes, or?
Yes.
Okay.
That is something kind of special. Let's say that you have a significant other that lives with you in your house, and you're concerned that if something happens to you, they will not have any place to go. They're not an owner of your house, they're not on the deed, but you want to make sure they're taken care of. What you can do in your estate plan is you can provide for a life estate for that person, that upon your passing, they have a life estate for the rest of their life. And then after that, the property goes to your heirs, not to their heirs, because it's a life estate to live there while they're still alive. Okay. That's what that is.
And I've known people in that kind of a situation where all of a sudden the spouse did pass, and now they were homeless, and so that's an awful way to be. So that's
prevent
something,
that situation.
Prevent that situation. Yeah. So something for people to think about. All right. All right. And how, people usually leave their things to relatives, but are there situations where they might leave it to other people, other entities, maybe a charity? Do you provide for those within the context of an estate?
Absolutely, and that can be done. There's actually a special provision that we use that's very popular for tangible personal property. And that's stuff that you can touch, tangible. It's not bank accounts, and it's not for real estate, which is land and houses, but it's for collections, guns, cars, furniture.
Mm-hmm.
And you can actually list off the item or the collection and say, this is my gun, and I want to leave this to Rick, with the name of the person who's getting it. And that way they will be certain to get that property because it's on the list. And we can include that with the estate plan.
Okay. All right.
Put it
Very
right in the book.
Okay. In the book. Where should that book be?
It should not be in a safe deposit box in the bank because they're hard to get into. So it should be probably at home.
Mm-hmm.
And if you have a home safe, that's very good because there's fire resistance.
Mm-hmm.
If you don't have a home safe, probably a freezer in a plastic bag because that also is fire resistant. And these are not valuable papers in the sense that you can't resell them for a lot of money, but they're very valuable in terms of what's going to happen to your estate. So you want to make sure they don't burn up. That's the biggest concern.
Okay. All right. So that sounds like something you really want to put some thought into in your overall estate plan. Is now that I've got these documents, how about copies? Are copies valid? Is this a document that had, oh no, you can only use the original?
Copies are valid for most things except for wills. And the Arizona law is that you have to submit the original will for probate if you're going to do a probate. And if you only have a copy, that's not good enough. There's a presumption if you don't have the original, or if the original is written on, changed, marked, torn, burned, or anything else, it's not going to be valid. So you need the clean original will for probate.
Okay.
We also do what's called a pour-over will with the trust, because what happens is people will forget about something. There's an investment account they had or a bank account, and they forgot to put it in the trust. And it's a big account. It's over $75,000. What can we do? Well, we can use the pour-over will that is probated to say, okay, this is something we forgot. Now we're going to put it in the trust with everything else. So there is a probate required at that point, but at least it's only for the item they forgot. It's
Okay.
not for everything.
Not for everything. Okay.
And it puts back into the trust.
Okay.
That's called a pour over because it pours back over into the trust.
Okay. Now, could somebody at a point like that, if they realize it, also just put that into the trust? Is there
Well, obviously, if they put it into the trust before they are deceased, then you won't have to use that pour over will.
Okay.
That's an alternate plan. That's Plan B.
That's a catch-all.
If Plan A doesn't work, we're down to Plan B.
Okay.
You got it all covered, though.
Okay. So Plan A is if you see it, you know it, get it in the trust.
Right now.
Okay. Very good. Very good. All right. Great. How about folks that have, maybe they moved to Arizona from another state? I mean, I myself moved from Michigan to Arizona a long time ago. Maybe got property back in that other state, or maybe even in a different country. What do we do with that in terms of estate?
Those are very good questions. If it's in another state, again, if you put it in the trust, and we may have to hire a Michigan lawyer to put your Michigan lawyer into our Arizona trust. But once it's in the trust, it's in the trust. We don't need to worry about probate in Michigan. So that takes care of it.
Okay. So you could be in probate in multiple states then if you don't do some of this stuff.
Every state has jurisdiction over its own property. So in Arizona, we cannot control the disposition of property in Michigan or Alabama or any other state. Every state is unique in that regard. There's something called ancillary probates. And that's the main probate is here because this is where you live and this is where you passed away. But you had property in California. So we have to go to California, hire a lawyer in California and do an ancillary probate to dispose of or sell the California real estate that you own. But again, if it's in the trust, we don't have to do that. So let's put it in the trust beforehand.
Okay. Alrighty.
As far as foreign countries, and I was just talking to somebody the other day that has land in Japan. Japan has an entirely different legal system than we do here in the United States. She is consulting with a Japanese lawyer, and I think that's a very wise thing to do. It may very well be that there needs to be an estate plan in Japan pursuant to Japanese law for that property. And she can also have an estate plan here in Arizona for her Arizona property.
Mm-hmm.
So she may have two estate plans. And that's okay. That's legal to do that.
Okay.
And sometimes very beneficial because, again, Arizona law very different from laws in foreign countries. People in Canada and British areas of the world, England and so on,
Mm-hmm.
very different system. They don't even recognize what we call living trust. Every trust to them is, as I understand it, an irrevocable trust. And so if we create a living trust, which is revocable or changeable or amendable here in Arizona, they recognize it only as an irrevocable trust that has its own tax ID number and its own status as an entity.
Mm.
And what will happen is we put their property in Arizona into their living trust and they're Canadians. Canada will decide that they've had a taxable transfer or sale of that property, and they'll have to pay income tax. So I'm not going to be doing living trust for Canadian citizens because I don't want that liability.
Yeah. Okay.
But they don't recognize the form that we have here. They only recognize a different form.
Okay. Yeah. So the laws not only different from state to state, but obviously from country to country.
Very, very different.
When you get right down to it, and you look at the way our nation was formed, we call them states, and we think of that as little sections of a country. But I mean, the word state means you're the top dog.
They have their own laws.
They have their own laws
regarding estate planning, probate. They're not the same.
Mm-hmm.
The process is not the same.
Yeah. Okay. And there, if you don't believe that, there's a lot of lawyers doing podcasts out there on the internet from different states. Just listen to a couple of them, and you'll know it's like, wow, he ain't from around here, is he?
Right.
All right. How about should a person only have one will or one trust, or are there other reasons? Like you mentioned, if you've got property in a foreign country, you might have to have an estate plan there and one here. Are there reasons people would have more than one trust within the context of the United States or within Arizona?
Within Arizona, I wouldn't think so. I think there just needs to be one.
And two would cause confusion? Or?
It definitely would cause confusion. Okay. And generally, when you do a new estate plan, you're going to revoke any previous estate plan.
Okay.
If you do a new will, for sure, it says, this is my will, I revoke all my prior wills. So
okay.
That would be a mistake, I think. But it is possible, I suppose, that if you didn't have a trust and you have property in other states, you might want to have a separate estate plan for that property in that other state.
Okay.
And in which case you better be very careful in the drafting that you don't put the standard language into the will, which says this is my will and I revoke all my prior wills. Because you're going to need to say, well, this is my Arizona will, and I recognize that I still have a Michigan will, and it's valid as well.
Yes, yeah.
But that's not the standard language.
Yes, yeah. I actually heard of a case one time of an individual who simply had a will, and they wanted to make a change to it, and they decided to do it as a DIY project, do it yourself, and put the standard language in there because they just copied down what was in the other one rather than going to an attorney and then put that one item in there. And so that was the only item that was handled by that will, and everything else that was in the previous will was null and void. So that would be tragic. To me, it sounds like this is a labyrinth of, well, I come from the programming world. we had something called if-then statements. So if this, then this, or if this, then this. So it could get pretty complicated. This sounds like one of those situations to me, Doug. It sounds like this is a complicated process that you probably don't want to tack on a Saturday afternoon as a do-it-yourself project. Would I be
Some of the
right?
hardest cases I have done were people that did it themselves
Hmm.
and created all kinds of complicated problems.
Right.
So I don't recommend that at all. Um, for the same reason that I take my car to a certified mechanic. I don't do it myself.
Right.
I want my car to run.
Yeah. Yeah, that's a nice benefit.
Yeah.
All right, very good. So, so you want to get a professional to help you with your estate plan, somebody like yourself that knows those intricacies, can make provisions for them, and make sure that, you know, if you have those situations where, oh, you own something somewhere else, you account for that. You know the questions to ask to make sure that those things are covered and handled. So that's an important factor. Anything else about the whole process of estate planning in general that you want to tell folks?
Well, we could probably go on for hours.
I'm sure we
But,
could. We could create a estate planning 101.
our time is limited for today. I'd like to do some more videos and maybe more specific on various topics,
Mm-hmm.
and maybe we can do that in the future.
Okay, very good. All right, we are here today with Doug Price, and we're in Tempe, Arizona.
Correct?
So if you are looking for somebody to help handle your estate planning needs, somebody who knows the right questions to ask to get down to the nitty-gritty and make sure that your estate is planned properly, that when you do go, or if you're almost gone but not quite, all of the right things happen. Is that a good summation?
I think so.
All
And I
right.
appreciate the questions.
All right, Doug, very good to be with you today. Thank you very much.
Thank you, Rick.
Okay.